Thank you so much for joining us. You're watching All Angles. I'm Dion Jackson-Mill, and a very special welcome to our viewers on onespotmedia.com. And joining us this evening to talk through those issues, we have the president of the New Kingston Citizens Association, Roger Chang. Also with us, urban conservationist, architect, and director of MPhil PhD in the Built Environment Program at UTech, Dr. Patricia Green. Chief Executive Officer of Better Homes and Gardens Real Estate Jamaica, Edwin Wint, is with us, as is Natasha Rickard. She's a real estate attorney with Myers, Fletcher and Gordon. Before we go to our guests, though, let's look at this overview of the ruling. Supreme Court Judge Judith Pusey refused an application to modify a restrictive covenant with potentially devastating consequences for the occupants of this townhouse complex. This is Upper Montrose Road, a quiet street of single-family homes. Enter the Lynns.
They purchased the property in 2017, and then they applied to the court for permission to modify the covenants, because once you have those covenants on your title, it requires an application to court in order for them to be removed or varied.
Emil Leiber, co-head of litigation at Duncox, represented neighbors who objected to the application to modify the restrictive covenant. Restrictive covenants are contracts between neighbors setting out what you agree will be done with your property. In this case, the covenant only allowed construction of single-family dwellings, not multi-family dwellings like a townhouse complex. The developers received planning permission to build 2 two-bedroom townhouses and 4 one-bedroom apartments. But the planning permission was subject to the restrictive covenants being modified. If your neighbors have a problem with your application, they can go to court. As required by law, the Lynns gave their neighbors notice of their application.
So they would have served those who are entitled to the benefit of the covenant, some of whom were my clients. And they then would have filed their objection to say, listen, we are objecting to your application. We don't want you to modify these covenants. We want it to remain single-family dwelling.
So the dispute was pending in court, but the Lynns started to build.
There was a cease and desist letter that was issued by my firm on behalf of my clients on the basis that they were building before the covenants had been modified, which was a very important point in this case.
A previous court decision had dealt with an application to modify covenants on a property nearby.
The applicants there had sought to modify the covenants before they commenced construction. So realize now that those 2 lots there, they're green space. Because those covenants were not modified, they did not build.
The neighbors saw construction continuing.
So we did a cease and desist. We applied for an injunction. We secured an injunction from the court.
The December 2018 injunction prohibited construction and also stated there should be no occupation of the complex. But the Lynns completed construction and the complex is now occupied. They also breached planning permission and added a 3rd bedroom to the townhouses. Mr. Lynn told the court this is done all the time without the approval of the KSAC, so he just went ahead and did it. The court then heard the dispute over the modification of the covenant.
If the developers had not yet built, then the issue of demolition and so on would not arise, because whatever building was on the property would have been in compliance with the covenants that existed on the title. But having built the multifamily dwelling before the court was able to decide whether or not those covenants should be modified, this is where we ended up.
The court refused the application. The court also ordered the development modified where it breaches the covenant and the structure converted to a single residence dwelling house.
That aspect of the claim is still not finally determined because we're supposed to go back in March for the court to hear submissions as to what a modification would look like.
The court said Mr. Lynn clearly had little regard for either the KSAC or the court and said this unlawful conduct and the advancing of self-interest over the rights of others cannot be ignored. But why would the court refuse the application? It's about what's called the character of the neighborhood. The judge visited the area and concluded Upper Montrose Road was characteristically different from neighboring roads. She described Upper Montrose and South Hopefield Avenue as an oasis in the middle of surrounding roads and said Upper Montrose had maintained unique, large single residences with large gardens. The Gleaner published this video showing the area around the townhouse development. But Emile Leiber explains the key question is where exactly constitutes this neighborhood.
In this case, the Court of Appeal had already defined the neighborhood for that area, and that neighborhood was Upper Montrose Road itself. So it didn't include Hopefield, it didn't include Donhead, it didn't include Seymour. It was limited to Upper Montrose Road itself. And when you looked at Upper Montrose Road, it is comprised of single-family dwellings solely, save for this development. That was before the court.
Isn't there any, surely if that argument were to be used in every case, Kingston could never grow and develop though. So what was the wider applicability of this?
Well, I won't say Kingston could never grow and develop. It's a question of the objection, because it's a contract between you and your neighbor, very loosely put, your neighbor can agree. So if your neighbor does not object to the development, has no difficulty with a multi-family dwelling being next door or in close proximity, then you can develop.
So what's the message from this ruling?
Compliance with the law.
All right, well, let me ask Ms. Rickards first of all, because there's been so much attention given to this ruling. Is it unusual?
I believe that. So, first of all, restrictive covenants are modified on a daily basis. It doesn't only affect developments. In one-off sales, we have to modify covenants. And so it is not an unusual hearing. What is startling about this particular judgment is the order to demolish and convert the development back to a single-family home. And so everybody is taken aback and trying to figure out how is this judgment going to actually be enforced after this developer has spent so 100 million, he says, develop on the land. So I think the order to demolish is what is startling.
Is that, though, the argument, I've spent $100 million on this development, is that an argument before the court? Because one of the things the judge said, she quoted that legal phrase, he who comes to equity must come with clean hands.
Right. So he did mention that, in the case, and it was included in his submissions, but there was blatant disregard to several notices and objections and the due process that's supposed to take place in an instance like this. And so he was ordered to stop the development until the issue was resolved, and it continued for whatever reason, and this is a result of the disregard.
Mr. Wint, as a real estate professional, what's your reaction to the ruling?
A bit startling.
Startling why?
Startling because it's the first that I'm aware of such a ruling after the fact, meaning after completion. And it's going to have, it is having ripple effects, I believe, through the industry. So it's left to see how it's resolved.
What are your colleagues saying? What are people saying?
Well, I mean, strictly speaking, all realtors look to the real estate board, and we check first to ensure that the developer and the development is approved by the real estate board, and their stringent criteria that they use ensures full compliance. So we don't take the listings unless they are in compliance with the real estate board.
Okay.
So we're hoping that that will suffice for us going forward.
All right. Dr. Green, for you, what's your reaction?
The reaction is that the citizens, the people of Jamaica, are actually speaking out and being proactive about their neighborhoods. We're seeing a lot of development taking place. As a profession in architecture, we recognize that some of these developments are not being done by registered architects. And so there are some issues that, you know, come into play when you're not dealing with a professional. And when there's a professional, there's a kind of pressure on the professional to deliver. And so against this background of compliance, non-compliance, some precedents, and usually changes of covenant take place with precedents. So if there's a precedence of an earlier development which with, you know, where there was a change of use or became from the density was changed, then that sets a precedence for your new development. And so in an environment where things are moving all the time, you know, it's changing so rapidly, then it's difficult for professionals within the context of approval systems and so on to really negotiate and navigate on behalf of clients and the market, because
Right.
there is a demand.
Hold that thought for me. I have to go to the break. When we come back with Mr. Chang, and we continue to talk about these issues and what does this mean for you. Suppose you see a big apartment building going up and you don't like it. Can you do anything, or would the boat have already sailed? That and much more when we come back. Remember, our hashtag is TVJ. All angles soon come.